Get things going. My name is Hank Schulz. I'm with We the People here in Texas. Our main speaker is going to be Bob Schulz. He's the chairman of We the People Foundation for Constitutional Education. And we're going to talk about how we get back to our constitutional republic. Bob can probably give you a bio if people are not familiar and want to know something. I don't know if he wants to go through all that, but maybe a little short one. But let's just welcome him, Bob Schulz from We the People Foundation.
Thank you all very much for coming. It's good to be back. Thank you, Ron, for opening up the facility again. This might be my fourth or fifth time here over the years. Pretty important issue, I think, to be most important in my life. I've been addressing government wrongdoing for a long time, but this project that we're embarking on now is hands down the most serious and important of them all. Our Constitution, our republic, is, I'm sure I don't have to tell patriots in this crowd that have been aware of what has been happening to the country, but the republic is in danger. It's hanging, the Constitution is hanging by a thread. There are people running in government that seem to be bent on transitioning our constitutional republic to a democracy. Everything is getting couched in political terms. If we don't like what's going on, vote for somebody else, is what we're being led to believe. So what we're going to do is talk a little bit about what the Constitution is, what it isn't, and what the founders did when they found themselves in a very similar situation. And what they did to hold the government accountable, what they tried to do before they eventually decided to separate. And then what I think we have to do, I see no other choice. I've been doing this kind of work for a long time, and we've been attempting to hold the government accountable by constitutional means, nonviolent means, using the right to petition clause provision, which we find in both our state and federal constitutions. So just in a nutshell, I don't have to tell you all, I'm sure. Constitution's a set of principles. What I'm holding here is put out by the Cato Institute. It's got the Declaration of Independence, which is the Charter, and the Constitution, which is the bylaws. And those are the founding documents. By the terms of these documents, we, the people, have set up the government. By the terms of these documents, we have enabled the government to do its job, but we've also heavily prohibited and restricted the government from doing a lot of things. And so this Constitution is a set of principles to govern the government. We're not mentioned except when the people adopt it. And it's all that stands between us and total tyranny and despotism. What I'm going to do is ask. We've got a couple of PowerPoint presentations to facilitate the discussion, move it right along. The first one of these is on our website now. If you want to know more about us and the foundation, it's all in this corporate brochure that we have. If you'd like some more of these, let me know. I have plenty of them in the van. This is the first of meetings across the country. We're in a different city every day now. And we have plenty of these on hand. They're not, obviously, not to be easily discarded. We put a lot of effort into these, a lot of expense, and we pay royalties, as you'll see, on some of those graphics that are included. So that tells you pretty much who we are. If you have questions about my personal background and what I've been doing, there'll be plenty of time for questions and answers. We can get into that, those of you who don't already know. All right, what we're going to do is begin first with a PowerPoint presentation that is already on our website, and then we're going to switch to a PowerPoint presentation that Hank put together for this tour that we're on. It's a little bit of overlap, but we'll get through these pretty quickly. You'll get a pretty good idea of the project that we're embarking on, this Continental Congress, not to be confused with a constitutional convention. They are different things entirely, okay? People are confusing them. Continental Congress, the first one, the founders well, let me back up. The French and Indian War ended in 1763, and the French are out of here. The English are left with a standing army. Standing armies elsewhere around the globe. They are ruling the seas. They're the most powerful government on the face of the earth. And they decided to treat the early Americans differently than they were treating their people back on the other side of the ocean. And our people, Jefferson in particular, would submit petitions for redress of grievances to the government. And as the Declaration explains, their repeated petitions were answered only with repeated injuries. And that eventually caused them to separate. But what they did back in 1774, they didn't decide to separate. They decided to send a few delegates representing the 13 colonies to Philadelphia, to Independence Hall, just to talk about those grievances that were building up, that they were filing with the government, and the government was not responding responsibly. So they got together to talk about that and to decide on a course of action. That's all they did, and that's all they decided to do when they headed out to Philadelphia. And it was only during the course of that Continental Congress, particularly with the persistence of Adams, that eventually they decided to separate, that there was no choice but to separate. Yes, Hank?
Could you hold the microphone a little closer so we can get on the tape?
Yes, okay.
That's
Good idea. All right. So, and we find ourselves in the same position. We have been, those of you who are familiar with our organization, I'm sure many of you have been petitioning your government in one way or another for a redress of grievances, particularly grievances dealing with a violation of your state or federal constitutions, and maybe not happy with the response you got. Well, we as an organization, me in particular, have been petitioning our government intelligently, rationally, professionally. Our federal government, for 20 years I did that with some measure of success, but in the late 90s I began to petition the federal government because of its violations of the Constitution. Maybe not expecting the relief we were asking for, but clearly setting out to establish a record, just as the founders did. They were justified in taking the action they did because they could point to a record of repeated infringements on their rights and their repeated attempts for redress or remedy. Redress means remedy. And government's abuse of them, answering their petitions only with repeated injuries, as the Declaration of Independence explains. So we set out some years ago and have been petitioning with the assistance of constitutional scholars in a very professional, intelligent, rational way. We have been submitting petitioning either the judiciary or members of the executive and legislative branches directly, members of Congress, the president, and so forth, and without a response, clearly without a responsive response. And so we have reached this point where we think we need to bring up to 3 people from all of the 50 states together in Philadelphia, not at Independence Hall, but they have a new facility, a few years old, called Constitution Center, on the other side of the Liberty Bell that now sits between the Constitution Center and Independence Hall, to discuss these violations of our Constitution, our repeated attempts for remedy to these grievances, government's continued abuse, their deaf ear that they've turned to this, and then settle on a course of action. But at the same time, and this is key, at the same time communicating back to the people in their states through state websites, which will become the sort of the potbelly stove around which people will gather, and you'll have discussion boards and chat rooms and so forth. These delegates in Philadelphia will populate their state websites. They'll have the responsibility of doing that every day. Those people back home will know what these delegates have been discussing, what they've been debating, what they've been deciding, and then when they settle on a course of action, hopefully there'll be 5% or more of the population that is properly up to speed and willing to collectively participate in a collective action to put a collective foot down against the tyrants of our day. So with that as an introduction, Hank, if you could, we'll run through these pretty quickly to give you some basic grounding in some of the principles that are involved here. Next slide. This is the First Amendment. In its entirety, it reads, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So there are 5 freedoms guaranteed by the First Amendment. In the order that they're mentioned, it's worship, speech, press, assembly, as we're doing here today, and then petition for redress of grievances, petition for a remedy of grievances. Everyone by now is familiar with the first 4 of those freedoms. They're familiar with the rights of the people and the obligations of the government under the first 4 freedoms. They have been the subject matter of lots and lots of lawsuits, gone all the way to the Supreme Court. Lots of people have chimed in, and and so by now we pretty much know the full contours of the meaning of those first 4 freedoms. Unfortunately, the last of those 5 freedoms, the right to petition for redress, for a remedy of grievances, especially violations of the Constitution, no court in an entire history of America has ever declared what those mean. What are the rights of the people and the obligations of the government under those last 10 words? It is, those 10 words are the accountability clause. There are benches over here, or steps, if someone would like to sit. Thanks. And chairs. Yes. Set some chairs up over here. We get a couple of hands to set some chairs up. Some folks over here. I have to apologize, by the way. I'm from upstate New York, and I'm a Texas border over there. That's what we do up there. Thank you. Okay, so what does these last 10 words, what do they really mean? Where do they come from? What role did the right to petition for redress play in the founding of the country, and what should it play? What meaning should we be given to it today? So we'll talk about the right to petition. Next slide. You can't read this, but the first recorded mention of the right to petition, what it means, you find in the Magna Carta. The Magna Carta was signed in 1215. Remember, back then, the monarchy had absolute power. The king and queen, they could do whatever they wanted. You couldn't sue them. Absolute power. They were considered representatives of God, on earth and so forth. Could do no wrong. And so it's a pretty historic, significant thing. The Magna Carta is the cradle of liberty. Everything evolved, since then. And to give you some idea of the meaning of the right to petition, we find section 61 of the Magna Carta. It reads, and the king signed this document. This is, it was signed, of course he was confronted with some of the barons and of course some of the community, people in the community. They had their pitchforks and so forth. And so there was sort of a little threat behind all of this. But the fact of the matter is the king did sign it. And it says in section 61, if we, our Chief Justice, we meaning the monarchy, he and the queen, or our Chief Justice, our officials, or any of our servants offend in any respect against any man, or transgress any of the articles of the peace or of this security, and the offense is made known to 4 of the said 25 barons, they shall come to us, or in our absence from the kingdom, to the Chief Justice, to declare and claim immediate redress. So the people, if they feel their rights are being violated, they can petition the monarchy. If we, or in our absence abroad, the Chief Justice, makes no redress within 40 days reckoning from the day on which the offense was declared to us, or him, the Chief Justice, the 4 barons shall refer the matter to the rest of the 25 barons, who may distrain upon and assail us in every way possible, with the support of the whole community or of the land, by seizing our castles, lands, possessions, or anything else saving only our own person, and those of the Queen and our children, until they have secured such redress as they have determined upon. Having secured redress, they may then resume their normal obedience to us. Pretty significant. Here you have the monarchy saying, if the people have some gripe that feel we're infringing on their natural rights, bring your petitions to us. We have 40 days to respond. If we don't, you have the legal right to take everything we own, our lands, our castles, everything except my life, the life of the Queen, and the life of our children, and the life of the Chief Justice. And then once you've secured your remedy, then you are obligated to restore your allegiance to us. Pretty significant when you think of it. Next slide. So we have and following that day, the right to petition grew and grew and was applied and followed. And to give you a little story, in around between 1615, 1650, the king had leanings towards Rome, Catholicism, and so he thought he'd do a pretty cool thing. He issued a proclamation, and he said the people of the kingdom have the right to worship any way they want to worship, and I would like this proclamation read from every pulpit in England on this particular day. And there were bishops, cardinal, that thought, well, gee, wait a minute, there's a problem with this. If we go along with this, we will be admitting that this right to worship comes from the king rather than from God. So they sent a contingent of 6 bishops to talk to the king about this. And the king heard they were coming, and he was delighted until they got there and they told him what was on their mind. And he immediately put them in the dungeon. And there was a trial. Thank God there was a trial. And they obtained the services of a barrister. And the barrister argued, among other things, that, gee, they were just petitioning the king for a redress of this grievance. And the jury acquitted them. So the right to petition the government for a remedy to grievances grew and grew and found its way to our shores, and was very much a part of our founding documents and very much a part of our system of government here for many years. Up until around 1830, if you had a grievance against your government, whether it's county, state, or federal, say you submit your petition for redress to your congressman, until around 1830, your petition for a redress of a grievance always went to a committee. In Congress, every Monday was the day they dealt with petitions for redress of grievances. And you always got an answer. Compare that with today, okay? And so what happened in 1830 to begin to change all this? The Southern congressmen prevailed. They had it, with these petitions for redress from abolitionists to end the practice of slavery. And so they prevailed, and they got a rule passed in the House that any more of these petitions from abolitionists would be permanently tabled. First time government on these shores ever went on record saying we don't have to listen or respond to the people. And it's sort of been, sort of downhill. This right to petition it took John Quincy Adams 8 years to get that rule repealed, but the damage, of course, had been done. So now we fast forward to 1774. Again, the founders, the 13 colonies sent some representatives off to Philadelphia to talk about their grievances and what they could do about it. And while they were in session, the Continental Congress, in session, one of the acts they passed unanimously was an act entitled Continental Congress to the Inhabitants of Quebec. It was an act to be sent up there to encourage them to get behind this developing revolution in our country. And if we can, well, it's an 8-page act, and in this 8-page act, which ought to, that little, you don't have to click on it, Hank, but this little PDF symbol down here, if you click on there, when you go to the website, click on there, you'll get the full text of the 8-page act. But in this 8-page act, the founders are talking about the great rights, the grand rights of individuals. And in talking about the first of those, what they call the grand rights, the right to government based upon the consent of the people, they said this. It's down in the right there, but if you go to the next slide, we'll get it in larger type. Hank, you want to advance it one? These words are in that act. If money is wanted by rulers who have in any manner oppressed the people, they may retain it. They may retain their money until their grievances are redressed, and thus peaceably procure relief without trusting to despised petitions or disturbing the public tranquility. And you find that in this 8-page act passed unanimously by the Continental Congress. You find it in Journal 1 of the Continental Congress on page 105. So what are they saying here? They're saying retaining your money. If you have grievances and you've petitioned and the government is violating your rights, you have the right, the fundamental right to retain your money, thus peaceably procuring relief. It's a non-violent solution to problems that we have with our government. Without trusting to despised petitions. They knew, of course, from the Magna Carta on forward, they knew that the people had the right to petition, but they also knew government doesn't like opposition from any quarter. In fact, they despise these petitions when they get them from us, right? So without trusting to the despised petitions, we can retain our money and procure relief without disturbing the public tranquility. Next slide, Hank. Jefferson, very good with words, wasn't much of a public speaker, but he could really write, and this is the way he put it. Quote, "The privilege of giving or withholding our money is an important barrier against the undue exertion of prerogative which, left altogether without constraint, may be exercised to our great oppression. And all history shows how efficacious its intercession for redress of grievances and establishment of rights, and how improvident would be the surrender of so powerful a mediator. How dangerous, how wrong it would be to give up this power that the people have of giving and retaining their money in order to redress grievances and establish rights." Next, Hank. You'll find there's a lot of text, but what this says, in effect, is this. All these other rights that you find in the First Amendment are derivative rights. They all derive from a pre-existing essential right to hold the government accountable by petitioning for redress. As the historical record shows, and everything is footnoted here and so on, as the record shows, Parliament, what good is the right to petition the king if Parliament couldn't get together and talk about it? I mean, the king had the right to dissolve Parliament and put another one in if he didn't like what they were doing. And he did it often. So the right to free speech derived from the pre-existing right to petition for redress. And what good is the right to petition for redress if you couldn't write about it or get together and talk about it in Parliament or anywhere else? So these fundamental rights that we do know about, speech, press, and assembly, they're derivative rights. They derive from that fundamental right to be able to hold your government accountable. Think about it. Would the founders have given us this wonderful system of governance in the founding documents without giving us, the people, some means within the Constitution itself to hold the government accountable, non-violently. Of course, there's the Second Amendment. But would they have given us, without that, those 10 words, that right to petition government for redress of grievances, was put in there as a critical element of the overall balance of power between the people and their government. Next slide. Also, it's clear from the historical record that Congress, the government, anyone petitioned, whether it's the judiciary or the president or the Congress members, they are obligated to respond. And we clearly prove that with our historical documentation. It's all part of this PowerPoint presentation on the website. Go ahead, Hank. So then that brings us to the 1776 and the Declaration of Independence. Hank, if you could click on the PDF, it'll bring up the Declaration. We don't have a white screen here, which is a real disadvantage, but you see the PDF right there on the screen?
Yeah.
Oh yeah, okay. You want to scroll up? Just move it to the right a little bit and scroll up.
I can't move to the right.
You've been moving it to the left. Can you move it to the right? All right.
Well, I can do it this way. I can do it this way.
All right, I'll paraphrase. So there they were, the founders. They went to Philadelphia to talk about their problems and what to do about them. They started in 1774. By 1776, they had come to the conclusion that they were going to have to separate. And the Declaration of Independence, what it says in essence is, look, we owe it to the world to explain why we're doing this, right? A respect for the opinions of mankind leads us to want to explain why we're doing this. And so in the first large paragraph, you have some of the words you're all quite familiar with, of course. Go back just a little bit, Hank. You had it there. Yeah, okay. So, we hold these truths to be self-evident, and all men are created equal. They're endowed by their Creator with certain unalienable rights. That's key, of course. Our rights don't come from government. Your rights are individual rights. You have them simply because you're alive. And where people become alive is debatable in our society, I understand. But we have them because you have life. And they don't come from government. They're unalienable. They're endowed by the Creator. They do not depend upon the will of any majority, whether it's a majority of the people voting on election day, or whether it's a majority of the people voting in the halls of Congress, or whether it's a majority of the people voting on the bench at the Supreme Court. Your individual rights do not depend upon the will of any majority. Please understand. I'm sure most of you do. But that's not what's happening in our country today. We're transitioning to a democracy, and oh gosh, let's not hold Mr. Obama's to the Natural Born Citizen Clause. Let's not have him prove his eligibility under the Natural Born Citizen Clause of the Constitution, because to do so would be to overturn the will of all of those 65 million people that voted for him. And, you know, it just drives me crazy. But anyway. All right, so among these are life, liberty, property, pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it, institute, and so forth. Then we have you want to scroll down? Now we have the listing of the grievances. If the Declaration of Independence is 5 pages in here, 3 of those pages are devoted to a listing of the grievances. Okay, we don't have to go through all of them, but just go down slowly, Hank, so people can get a feel for what those grievances are. And you really should go back today and spend a little time, just review that Declaration of Independence, because that's where we are again. We've reached that point. We've got to get together and discuss these issues and what as a free people, what we're going to do about it. Many of these grievances they had back then are being revisited upon us. You'll see as you go through your version, your copy of the Declaration. Okay, scroll to the, keep going, I'll tell you when to stop, Hank. Keep going. Okay, now, a little higher. Yeah, there, right there. Now, after that listing of grievances, this paragraph, this two-sentence paragraph that begins, in every stage of these oppressions, the scholars call that the capstone grievance. It is clearly the grievance which capped all the others. It is the grievance, more than any other, that led to the separation. Here's what it says. In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which would define a tyrant is unfit to be the ruler of a free people. They would consider themselves free, and they petitioned over these violations of their rights. Their repeated petitions were answered only with repeated injury, and they decided that a prince or a government whose every act defines a tyrant is unfit to be the ruler of a free people. And the rest of it, of course, goes on and says basically, we're out of here. If you don't like it, come get us. So that's the Declaration of Independence. You want to go to the next, go out of that PDF and go back to the PowerPoint, Hank? Okay. And so here are those words, the capstone grievance. In every stage of these oppressions, we petition for redress in the most humble terms. Our repeated petitions have been answered only with repeated injury. A prince whose character is thus marked by every act which may define a tyrant is thus unfit to be the ruler of a free people. The capstone grievance. Next slide, Hank. Next slide. There's a preamble to the Bill of Rights. It essentially says that, they were passing the Constitution now to be ratified by the 13 states, and the preamble to the Constitution, in effect, says a number of the states want a Bill of Rights before they'll approve the Constitution, and so that they would be, in order to prevent misconstruction or abuse of its powers, a Bill of Rights that further declares and restricts, would have more restrictive clauses should be added and so forth. Okay, Hank? What's interesting, I find, I haven't checked all the state constitutions, but I like the New Hampshire Constitution. It has this, it's still there. It was put in there initially, and it's still there today. Here's what it says. It's Article 10, it's the right of revolution. Government being instituted for the common benefit, protection, and security of the whole community, and not for the private interest or emolument of any one man, family, or class of men. Therefore, whenever the ends of government are perverted, and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may, and of right, ought to reform the old or establish a new government. The doctrine of non-resistance against, this is key, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. That it is nuts to be abused, have your rights trampled on, and to adopt the doctrine of non-resistance. It just doesn't work. So much for the New Hampshire Constitution. Hank? Of course, the Ninth Amendment, here's what we have come down to believe those 10 words mean in its simplest form, based upon our review, thorough research of, well, it's common sense, but I mean our review of all the written record, both overseas and here. It means this: if we have some evidence that government is violating some provision of the Constitution, and we call them on it by petitioning for a redress, and if they don't respond, or if they respond with repeated injury, then we have the right to withdraw our support from that government. And in effect, they have said, this doesn't matter anymore. Well, if that doesn't matter anymore, then why would we want to continue supporting them? Right? That's what that accountability clause in the First Amendment means. And if there's any, some people say, we've had this issue in court. Some people say, well, gee, Bob, it says right here that people have the right to petition the government for redress of grievances. It doesn't say the government has to respond. So I said, well, okay, fine, let's go to the 26th Amendment. It says the people have the right to vote. It doesn't say the government has to count the votes. Of course, every right that is not enforceable is not a right. Of course, there was an implied requirement on the government. Why put it in there if government didn't have to pay attention to it? So, but if we have to, we can always resort to the 9th Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Well, okay, if you don't think it's embedded in those 10 words, then how about, the 9th Amendment? We claim it, okay? And of course, the next slide, there's one other accountability clause, and that's the Second Amendment, a well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed. Being necessary to the security of a free state. If that isn't a demand that there be well-regulated state militias, then what is it? So the absence of well-regulated state militias today is unconstitutional. And the National Guard is not the well-regulated state militia that's referred to in the Constitution. First of all, there are many reasons, but one I like to give is, first of all the weapons are over there in that armory. They're supposed to be over our mantles or in our home someplace. Okay, let's go to the next slide, Hank. On our website, we have 10 or 11 law review articles which thoroughly discuss the history, 2 of them in particular. The first one up there is the Vestigial Constitution out of Gregory Mark, a professor out of Fordham, but it was, he's out of Rutgers, but his law review article was published in the Fordham Law Review. And another one on here here it is, the Rights as a Constitution, Bill of Rights as a Constitution by Akhil Amar at Yale. Very thorough historical reviews of the right to petition. So on our website, you can find your way, they're all there, and read these law review articles that address the right to petition. Hank? We have, as I say, been petitioning for redress of grievances, doing we think, with the assistance of constitutional scholars, we have been petitioning the judiciary and petitioning Congress and the executive branch directly as we have evidence of violations of the Constitution. And these petitions for redress, at least the form that we prepare them in, we view them as depositions. In each one of these petitions for redress of grievances, we have a series of one-sentence statements of fact. So one sentence, this is a fact. We can support that. We have evidence that that is true. And we add 2 words up front of each one of those single sentences, admit or deny. So government, admit or deny this, admit or deny this, and so forth. Facts. And so there's a series of questions embedded in each of these petitions, and they've all been served on the government, and they refuse to respond. Most recently, on June 30th of this year, every member of the House and the Senate and the President were served by these petitions for redress of grievances by one or more of their constituents. So constituents serve these people. They didn't have the excuse of saying, oh, something comes in the office as they like to. as they like to do. Oh, that's not from one of my constituents, and they trash it, okay? So we had these served on them, and with proofs of service. The person in the congressman's office who served it, who received it, signed that they received it, and the person serving it signed. So there's proofs of service that they were all served, and no one has responded. Ron Paul did something different from the others. He submitted it to the clerk of the House to be given to the Speaker, there to be discharged according to the will of the House. I had an intense hour and a half discussion, no one else in the office, the Washington office, Ron Paul, but his chief of staff, Tom Mazzaro. And we went through this. There's a reluctance on the part of the staff to respond to petitions for redress of grievances. Why? Because, gee, Bob, if we respond to your petitions, then everybody else is going to be submitting petitions for redress, and they're going to be looking for a way, you know, you responded to we the peoples, why don't you respond to ours? And they'll come in over the transom, we'll be overwhelmed, we don't have the staff, we don't have the budget, and so forth. Excuse me. You know, I said, Tom, look, yeah, it might be a little busy at first, but once we get the government under control, things will slow down, you know. Every now and then there'll be a petition for redress. But in any event, it was a real bureaucratic response from Ron's staff. And it was wrong. It doesn't relieve Ron Paul of the individual responsibility of responding to these petitions. In fact, in 2001, I was on a hunger fast in Washington, and we held a press conference down there with Ron's help and Congressman Bartlett on the House Triangle because they weren't responding to the first of these petitions we submitted. And Ron and Congressman Bartlett were there, and Ron made the statement, there is an inherent right in those 10 words that government must respond. Government has the obligation, he said, to respond. It's all part of the inherent right of petitioning for redress. But nonetheless, the staff, he really depends on his staff entirely, and the staff prevailed. So you'll find these petitions on our website as part of this PowerPoint presentation and otherwise. We have petition for a redress. It is unconstitutional to apply the armed forces of the United States in hostility overseas without a declaration of war. It is unconstitutional to do that. The last time we declared war was World War II. Of course, we haven't really won any wars since then. But, and so Ron Paul did a great job when, you know, it's well understood now that President Bush has, from day one, has always wanted to go into Iraq for whatever reasons. And eventually, someone, you know, said, well, what about Congress? And so, because of the Constitution. And so they prepared, the White House prepared what's called the Iraq Resolution. And they sent it over to Congress to be passed, and then to come back to him for a signature. And if Congress passed that, it would have been, which they went on and did, it would transfer the power of Congress to declare war. It would give the power to the president, essentially saying to the president, you decide if we're going to go into Iraq and when and so forth, instead of Congress doing their job. But the way it's designed to work, if the president feels we have to apply the armed forces of the United States in hostilities overseas, there's supposed to be a debate on the floor of the House and the Senate, and they're supposed to ask all the tough second and third order questions to get to the bottom of things and then declare war. But that's not, you know, what they did. So this Iraq resolution that Bush sent over to Congress fell to the House in October of 2002, some 5 months before we went into Iraq. It fell to the House International Relations Committee chaired by Henry Hyde. And on the second day, October 3rd, Ron Paul was a member of the committee, his turn came to speak. And he did a really great job. You know, it's all in the transcript. We have it on our website. You can easily get the full transcript of that hearing by going to house.gov and then going to the appropriate House International Relations Committee, then going to October 2nd and 3rd of 2002. But what he did was say to them, look, you're debating the wrong resolution here. And he said, I'd like to substitute a resolution for the one that came over from the White House. If you pass this, you'll be declared war. And he did a great job of quoting the Constitution, the meaning of the War Powers Clause, quoting Madison and so forth. But when he was finished, here's an indication of the problem we are now facing. When he was finished, Henry Hyde said this: "Events have overtaken the Constitution. The Constitution is anachronistic and inappropriate." So, in other words, we're changing it simply because, we think it's appropriate to do so. So they went on and voted Ron's amendment down, and then passed the White House Iraq resolution. And there's nothing in the Constitution that gives one branch the authority to transfer its power to another branch, and yet that's what they do. They have the White House, the president, often these days, more often, usurping the power of Congress and Congress acquiescing. All right, so the Federal Reserve System, we won't go through all of these, but clearly the Federal Reserve System is unconstitutional for many reasons, not the least of which is the money is not backed by precious metals, gold and silver. The USA Patriot Act is unconstitutional. It violates the privacy clauses. The Federal Reserve System, of course, violates the money clauses of the Constitution. You can scroll down a little bit, Hank. There are tax clauses in the Constitution. The current direct unapportioned tax on labor is unconstitutional. In Article 2, not only which deals with the power of the president, not only is he required to take an oath to uphold the Constitution, but he's also required to, quote, faithfully execute the laws. Now, there are laws on the books, immigration and naturalization laws. They've been there a long time. Whatever your belief or feelings about immigrants, illegal immigrants, these laws are on the books, and they're not enforced. Well, neither party wants to enforce those laws because they don't want to offend the Latino vote. That's what it gets down to. But they're there. If you don't like them, repeal them. But we're a nation under law. Let's obey the Constitution. It's another area where every time there's an issue in the country, I'm quick to go to say, what's the constitutional connection here? Is this a political question, or is it a constitutional question? If it's a political question, as an organization, we don't get involved. If government has the authority to do what it is they want to do, and whether, say, the state sales tax goes from 6% to 7%, and under the state constitution they have the authority to impose a state sales tax, then whether it's a 6 or 7% figure, that's a political question for the give and take of society. We don't get involved in that. We only get involved when there are violations of the Constitution to hold the government accountable. So when these issues come up, and who could fail to recognize how intense this illegal immigration issue has become over these last few years. And so, we just go to the Constitution and we say, well, what's the constitutional link here? Is there a violation of the Constitution? Well, there it is. It's the faithfully execute clause. If the president would faithfully execute the laws that Congress passed, then this problem would go away. Okay, North American Union. There's no authority in the Constitution for the government to stealthily or otherwise develop a North American Union, which would, in essence, eliminate the north and southern barriers of the country. There's no authority to do that. And so there's a petition for redress that's been, with the assistance of Ed Vieira, has been put together, served, and ignored. The right to keep and bear arms. Not only are the federal gun control laws unconstitutional, but the absence of a well-regulated state militia is also unconstitutional. And foreign policy. I, for one, believe that because of, and Paul, because of our presence and our involvement in interfering in the internal affairs of foreign countries overseas, propping up governments that are very oppressive. Those people are fighting their government, and it's true, say, in the Middle East and elsewhere. People are the same everywhere. They want individual freedoms and liberties, and so they're always at loggerheads with their government. And so the government is the enemy, as Ronald Reagan said, government is the enemy of freedom. That's true. And if those people begin to see that, you know, this government is what it is in large part because of the United States foreign policy and so forth, and its foreign aid and the rest of it, then maybe then what happens is people begin to see and say, well, the friend of my enemy is my enemy, and they begin to direct their hostilities towards us. And as they direct their hostilities towards us, we get a war on terror. A war on terror gives us a police state, and it's all downhill. So maybe we, you know, and so there is a clause in Article 1, right before the enumerated powers of Congress, that say, look, in doing all of these things that you're authorized to do here, keep in mind the general welfare of the country and the defense of the country, all right? Well, is it in our general welfare? Does it serve our national interest, you know, to interfere in the internal affairs of all of these countries around the globe if, by interfering, they're directing their hostilities towards us and we get a police state out of it? I don't think so. I don't think that's in our national or best interest. So anyway, there's a petition for redress on our foreign policy. And of course, since this list was prepared, we have the bailout of AIG and the $700 bill bailout and all these other